Good morning, sir. You are Asa Joseph Jones. In cause number 25, DCCR 0963, you're charged with aggravated assault, discharge.
Man facing life in prison just rejected 25 years. But wait for his answer to trial. Absolute chaos incoming.
Discharging a firearm recklessly. That's from June 12th of 2025, and that's a first-degree felony offense, which means if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Burbanks that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for 25 years in the institutional division of the Texas Department of Corrections. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty.
He said a no to rejecting the plea, but a no to trial too. Bro doesn't even know what he's answering, and his life is on the line. Judge West is visibly confused.
And do you understand all of that? And do you want to reject this offer and have your case set for trial? All right, I'll get that done. As far as you know, all the discovery, you have everything. Okay.
I'm not waiting on anything, Judge.
And is there any reason to believe that this offer would change, Mr. Coleman?
Not at all.
I want to make sure you understand, Mr. Jones, that after today, this offer will be off the table. If you change your mind later and want to enter a plea of guilty, you could do that open to the court or to some other plea agreement. But after today, this one's off the table. You understand? Okay, we'll get it set for trial. Mr. Burbank will begin preparation. Thanks. And then you have Kevin Ross. Okay, I'll take care of it in just a second. Let's get Calvin Randall. I can take care of Calvin Randall for Mr. Eckhart. We're just going on 2.
Yes, ma'am. Yes, ma'am.
529. Thank you. I'll need, can you do one for each? It's easier for them. I'm going to mark out the second number. If you'll do 1530 on the second one, please. Mr. Smith.
You marked out 15030. I need to write 1530?
Correct. Yeah, 1530 is what that one needs to be. And we're going on multiple counts.
Next up, Calvin Randall. 2 felonies, 2 10-year sentences. But here's the kicker. They run together, not back-to-back. Concurrent equals legal hack or fair deal.
They can both be counts one on the judge. Basically, we'll get 10.
All right, sir, you're Calvin Randall. And Mr. Eckhart, will your client waive the formal reading of the indictment in each case?
We do, Judge.
Mr. Randall, in cause number 24, DCCR 1529, you're charged with the second-degree felony offense of unlawfully carrying a weapon on alcohol premises, and I don't know what all those other letters stand for. IATWFZ.
That's the statutory name, Judge. I think it's in a correction facility or something like that, but it's not applicable here.
Just, I'm looking at the indictment. It says unlawful carrying weapon, alcohol premises, IATWFZ.
Weapons-free zone.
That's what it is.
Thank you. In a weapons-free zone. All right, and that is from May 17th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in cause number 24, DCCR 1530, You're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from May 17th of 2024, and how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Eckhart? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case?
No objection in each case.
It's admitted in each case. Is there any evidence that Mr. Randall is not competent?
No.
All right, Mr. Randall, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your pleas, find sufficient evidence to find you guilty, and in cause number 24, DCCR 1529, finds you guilty of evading arrest or detention. Good grief. That one is the unlawful carrying of a weapon on alcohol premises. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 1530, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that for any time that you've been in custody that the law gives you the right to receive. These two sentences.
Lifetime gun ban just dropped. Even after prison, touch a firearm? New felony. Texas said, we see your pattern. You're done forever.
Will run concurrently, which means together at the same time. I will sign as a part of this plea agreement the dismissal in cause number 24, DCCR 1278. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. Did I do? I don't think 1529 came through. Would you? They're going to, so also I'm handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Eckhart. All right, good luck to you, sir. And we're going to get that other one printed out in just a second. All right, thank you, sir. You can go back with the bailiff. We'll get it to you. Good morning. Are you Mark Garcia? And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Garcia, in cause number 25, DCCR 0120, the state has elected to proceed on count 1 only. It alleges you committed the state jail felony offense of theft of material, aluminum, copper, bronze, or brass, from April 7th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with?
Mark Garcia. For priors, same theft twice in 2 years. Judge calls this deal iffy. When does second chance become enablement? You decide.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? Answer out loud, please.
Oh, yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
This is going to be maybe iffy, but we'll look at it when I get. It looks like there's 4 prior felonies. 1 for the same offense, just in 2022. a theft on that same day, a possession of a controlled substance in 2023, and a fraudulent use of possession of possession of identifying information 2023. So it looks like the agreement that you've reached with the district attorney is for a cap of 16 months. Is that your understanding? I want to make sure you understand that, which means you're leaving your punishment up to me. If I follow the agreement, then I cannot give you more than 16 months. I could give you less. It'll depend on the information that's brought to me at a sentencing hearing. You have every right to have a jury come in and determine two things. The first is to determine if you're guilty or not. And then if they find you guilty, you can leave your punishment up to them. If we go forward this way, you're waiving that right. And is that what you want to do? Also, just so that you know, if I don't accept that plea agreement, you will be allowed to withdraw your plea and we'll go forward at that point. Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. If there's anything that you think it's important for me to know, get that information to Mr. Lewis and he'll present it to me on your behalf when we come back. Just anything that you think is good that would help you or help me to help you. All right? Do you have your discovery?
Oh,
Sorry.
Yes.
I just want to apologize again for
Well, let's.
tardiness of last time. You know,
he was a bond forfeiture judge.
Oh, okay. All right. Get Ms. Malfino to sign that real quick. Thank you. All right. Thank you, sir. You can go back with the bailiff. Good morning. You're Jared Dobbs. And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Get this pulled up, right? Sorry, it's taking a minute.
Okay.
See, Mr. Dobbs, in cause number 25, DCCR 1492, you're charged with the state jail felony offense of theft of material, copper, from June 30th of 2025. Your indictment alleges you were previously convicted of the state jail felony offense of theft, March 28th of 2019, and after that was final, you were convicted of burglary of a building and state jail felony, August 11th of 2020. And how do you plead to that charge? And are those two prior convictions true? And did you enter your plea of guilty and true freely and voluntarily, and because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Dobbs is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of theft of material, find those prior offenses true, sentence you in accordance with your agreement to a term of 4 years.
3 defendants, 3 very different outcomes. Judge West doesn't rubber stamp. She interrogates. Sub for more courtroom chaos. Would you take the plea or roll the dice?
Years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification. That shows that this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right? Good luck to you, sir. You go back with the bailiff.
Thank you.
Thank you.
Thank you.
Is Mr. West watching a video?